Good morning. Welcome, everyone. And I'm happy to be able to introduce Jennifer Stebbing. As someone already said, she's backed by popular demand. Jennifer Stebbing is a founding partner of Stebbing Butcher PC, a boutique estate and trust planning and administration firm in Brantford. Jennifer completed her Bachelor of Arts honors at the University of Windsor in International Relations and went on to complete an LLB at the University of Ottawa. And with many other continued education in law, she has tons of letters that can follow her name. Jennifer completed her LLM specializing in tax at Osgoode Hall Law School in June of 2019. She earned the Law Society of Ontario's Certified Specialist designation in Estates and Trusts in 2020. Outside of all of her law stuff that she does, Jennifer is a volunteer at heart and is involved in many different local organizations and spends her spare time hiking and participating in various community events. And I'm looking forward to this workshop. On to you, Jennifer.
Thank you so much for that wonderful introduction. Can I just have a nod from a couple people that you can hear me okay? You can see everything okay? All right, I got thumbs up. I'm good. Okay. Now I'll hide your faces and I'll be okay. So if you need to get my attention, someone will have to speak because I have the screen where I can see all your faces minimized so that I can see the slides well. So thank you very much for that introduction. I'm going to be talking about consent and capacity in elder law today. As mentioned, this is being recorded. And so it's best to try and keep your questions to the end because they'll stop the recording and then we'll be able to do those questions, and then that you won't have your questions out there in the YouTube world. All right. So my usual disclaimers, if you've come to one of my sessions before, this beginning part is going to be the same. This isn't legal advice. It's intended as a general presentation and may not be applicable in all circumstances. It's really just to give you background information so that you can better make your own decisions about what you want to do. There's no confidentiality between me and you here. You're not creating a client relationship with me because this is a public, even though we're all on computers probably by ourselves, it's still considered a public space. So when you're asking a question, if you're concerned about your own privacy or your own confidentiality, I think we can all live in the world where someone just says, I have a friend who, or a relative who, or something like that, and you can say your question and we'll all believe you. So you don't have to make it personal about yourself. About me, you know that now. I'm a practitioner in estates and trusts. I've been doing this for 16 years now. Been in Brantford for 3 years at the end of this month. And just so people know, in case they didn't see the notices in the paper at the beginning of this year, Lefebvre and Lefebvre, I have taken over we call it the solicitor practice. So I have all of their wills and powers of attorney here at my office. I actually have their corporate files and their real estate as well. So if you were a client of Lefebvre and Lefebvre and you're wondering where your stuff is, don't worry, we have it. We've had a lot of people check in to make sure we do, so you can also do that and just reach out and we can confirm we've got everything. And if you want to update something, we're here for you. The purpose of this session is to empower you to understand and protect your rights. So for you to understand what capacity is, how it changes depending on how your life goes, and how you can give consent in certain situations or you can't give consent. So, what is consent? Consent is more than just saying yes. It has to mean that you understand what you're agreeing to, that you're not being pressured to make that decision. And in Ontario, you have the right to make your own choices, especially with healthcare, as long as you have the capacity to do so. So, as long as you can understand the information being given to you, you are voluntarily giving your consent, and it's specific to that task or thing that's happening, then you're allowed to do that. So sometimes people aren't informed on the decision. And so then it's not a voluntary consent because you don't have all of the information in that situation. So if you're ever concerned about someone who's asking you to make a decision of yes or no if you want to do something, make sure you've got the first step, that you're informed. You have all the information you need to be able to make that decision. And then two, no one's forcing you to make the decision, and it's specific to a task. Examples of consent. And a lot of this is from my eyes because I'm a lawyer and this is the kind of things that I see. But there's a lot of other things you consent to during your life. So medical treatment, that means going to the hospital or not, having a specific surgery or a cancer treatment or something like that. Deciding to go to palliative care or to go home. Those are things that you have to decide on and consent to and have capacity to do. Includes where you stay. So if you're going to be discharged from hospital to your house, if you're going to go to long-term care or a retirement home, if you're going to move in with your kids, same thing. Who you see. This is one that I see in my office sometimes. You say you have 5 kids, you name one of them your power of attorney, but that power of attorney doesn't like their other sibling and wants to stop them from seeing you. If you don't have capacity to make that decision anymore, then your power of attorney is making that decision. That's your power of attorney for healthcare. And so they should be always encouraging the relationships you had before when you had capacity, but they do have the authority to restrict who you can see. You also can consent to sharing of personal information. So you can decide if anyone comes with you to a doctor's appointment, maybe they just come with you and they stay in the waiting room. But if you want them to come into the doctor's office where the doctor is, like in the room, then you have to consent to them coming in and consent to the doctor talking about things in front of you with them. Even though they're there, if you invite them in, that doesn't mean they get to make decisions for you. It just means they're there with you. Maybe they're a note taker or they're there to help you debate something, but they're not making the decision for you unless you've lost capacity to understand that information and make that decision yourself. You also have the decision of who can come to the bank with you, of who can access your financial information. I have some files where the older adult is still completely capable of making their own decisions and paying their bills, but they've never really done stuff online before and don't really trust how to do that. So they bring one of their children to the bank with them and ask them to give access to their child so their child can set up like the auto payments and things like that. So when you have capacity, you're consenting to that person having that information and accessing that information, but they're doing it with your permission, which means you can revoke the permission at any time. There's also consenting to legal agreements. So say you're going to move into a retirement home, they're going to have a lease you need to sign. So you need to be able to understand that and be able to deal with that. Same with mortgages or lines of credits, or even your power of attorney and your will. Those are legal documents. So what is capacity? First, it's the ability to understand information and appreciate the consequences. The really important piece of this is actually the last 2 words. It's appreciate consequences. You may have the ability to understand information and even say the information back to someone. But if you can't appreciate the consequences of the decision you're making, then you don't have capacity to make that decision. An example I usually give that most likely doesn't apply to you, but it's a way to understand what we mean by this, is that people that are schizophrenic can manage with certain medications, and their capacity goes in and out. So if they're having a manic episode and they're not on their medication, a lot of the time they're not capable of making their own decisions. But when they're on their medication, they're perfectly fine to make their own decisions. So if a schizophrenic they're having a manic episode, they're not on their medication, they can be taken to a hospital. a doctor can do what's called forming them, and it's just because there's a specific form the doctor fills out, and they can put them on 24-hour hold, 3-day hold, 5-day hold, 7-day hold, kind of depends on the situation. So they can declare them incapable of making a treatment decisions and making them for them. So when they're in hospital, then they're medicated, they come out of the manic episode, and they're capable again, so they can make the decision to leave. Say that person then has a conversation with the doctor and says, look, I understand I'm schizophrenic. I understand the medication helps me from having these manic episodes. And I understand if I don't take it, I will have them, but I don't want to take the medication. So that's someone appreciating the consequences. And they're allowed to make that decision because they have the information, they know the diagnosis, they know the medication, and they understand if they don't take it, what happens and the consequences of not taking it. So that person wouldn't be forced to take the medication until they have a manic episode again or incapable again and they go to the hospital again. If the person had instead said to the doctor, the voices inside my head tell me that I can't take the medication because it's going to kill me, that person doesn't um, appreciate the consequences of their action. Their reason for not taking it is not based in reality. So they wouldn't be able to make that decision for themselves. Decision specific. So whenever you having issues with capacity or consent, it's always decision specific and it can change over time. So the example I gave you where someone is going in and out of capacity throughout their life, depending on what's going on with them. And decision specific is actually a very important piece of capacity. So when I find people are aging and they get diagnosed with dementia or Alzheimer's, their ability to make decisions decreases over time. And it decreases, but kind of in the same order by topic. In the sense that like they lose the ability to manage their finances usually first, and the ability to manage their own personal care or healthcare decisions last. And so that's why we say it's decision specific. It could be that you've lost the ability to manage your finances, and so your power of attorney for property is managing now, but you still manage all of your healthcare decisions. And so you won't make the decision to pay your bills, but you will make a decision if you want a cancer treatment or if you're going to move into long-term care or stay at home. And the other interesting thing about that can change over time is that some people, they call it sundowners, but it's basically that the person's capacity decreases during the day. So in the morning when they're well rested and they're feeling good, they can understand what's going on and appreciate the consequences at like 8, 9, 10, 11 a.m. But if you talk to them at 5, 6, 7 p.m. at night, they're no longer able to appreciate the consequences or the information that they're given. So it's one of the reasons why we have so many issues with capacity and people's consent is that it can change so often, even during a day. So capacity law in Ontario, really important to know is that you are assumed to have capacity. So someone has to prove that you've lost capacity to make those decisions for those to be taken from you. I would say that nowadays, most healthcare practitioners, long-term care homes, nurses, doctors, they know this. Sometimes they make a mistake, but they do generally know this. Um, they may not always realize that it's uh, question specific and point in time specific, but they do know that you have the right to make your own decisions for as long as you are able to during your life. And then there's two statutes that deal with not only the presumption that you have capacity, but what happens when you don't have capacity. So the Healthcare Consent Act sets out who can make decisions for somebody if they're not capable of making the decision themselves. And the Substitute Decisions Act sets out how you do powers of attorney and how they can make decisions for you. Same for healthcare and for finances and guardianships and the public guardian and trustee, which I'll get more to that stuff later on in the presentation. So capacity and healthcare decisions. So you can say yes or no to anything whenever you want. You can, even if it's recommended by the doctor and you don't want to do it, you don't have to do it. You have the right to refuse anything you like. You have the right to leave if you're able to, as long as you have capacity to make that decision. And then capacity is assessed by a doctor, a healthcare practitioner, or a capacity assessor. So if this is a situation where you're in the hospital, and you just got admitted, say you had a fall, you've broken your hip, so they come and tell you, look, we've done the x-rays, you've broken your hip, we recommend this hip replacement surgery, this is how it'll go, and they give you all of the information, all of the what could happen, what couldn't happen, all the risks and those kinds of things. And if the doctor, the healthcare practitioner that is talking to you is concerned that you don't understand what's going on, they then might move to see if you are really understanding the like, is it an information issue, is it a language barrier, or is it a you can't appreciate the circumstances in that sense. And so the easier part of healthcare decisions is you're usually interacting with a healthcare practitioner at the time. And so they're able to assess if you can make that decision or not. And so that's, again, the point in time specific, question specific. So how is capacity actually assessed? There's a more formal process, which is with a capacity assessor. There's hopefully people know what the public guardian and trustee is, but if not, write a note and I'll explain it at the end if you like. But they, on their website, they have a list of all of the capacity assessors in Ontario, and you can search by region. And it has a little of information about the capacity assessor and also says like what their medical qualification is, because you can be a capacity assessor if you're like a social worker. I think occupational therapists can do it, nurses, doctors, psychologists, and psychiatrists can do it as well. They charge for what they do. It's a private fee. There's no OHIP coverage for that. It depends on who it is, what the price is. I've seen them range from 500 to 2,500, depending on the situation. The person meets with you at least once. It depends on the person and their process, what they're going to do to talk to you. And there's a bunch of different things they can assess you for, which I'll get to in a moment. But they're going to ask you a bunch of questions, and they always start off by first telling you your rights, that you have the right not to do a capacity assessment if you don't want to, what they're assessing you for, and then they talk to you about things. So for example, if they were assessing you for the ability to manage your own finances, they're going to ask you a lot of financial questions in the sense of like, where do you bank? Where does your income come from? What kind of expenses do you have? How do you pay a bill? Do you understand what a power of attorney is? What they can do, what they can't do, and those kinds of things. And then the assessor should also be talking with family or friends to get information from them so that they know if your answers are correct or not. Because I've seen this happen before. The assessor is like, they were great. They knew everything off the top of their head. And then we double checked the information and it was completely incorrect, like wrong bank, wrong bills, wrong income, all of that. So they should be double checking the information against another source. If it's a litigious thing or it's contested or people are arguing about your capacity, the assessor is supposed to be neutral. So say that again, we've got our 5 siblings and these 2 say you've lost capacity and these 3 say you haven't. And so you agree to get a capacity assessment. The assessor needs to talk to all 5. They can't just talk to the 2 that's saying that you've lost capacity because they're going to get a skewed result in that sense because this is what these people believe, but it's not what these people believe. So that's why they're supposed to do that process, is to make sure they have the right information and they're able to ask questions and know if the answers are correct or not. So as I mentioned, you have the right to refuse a capacity assessment. Just know that if you refuse one and this goes to court, a judge can order one. You can still refuse to do it. You can just sit there silent and not answer any questions. But the court will most likely make an adverse inference against you. So depending on the rest of the evidence, the court will just assume you don't have capacity and that's why you're refusing. So if you're ever in that kind of a situation, it might not help to refuse. There's some other cognitive tests that a lot of doctors use and we hear about online. And our president down south seems to think he's brilliant because he gets a perfect MMSE score. So MMSE is a MOCA. So MMSE is the mini mental state exam, and the MOCA is uh, Montreal something something. I can't remember what the acronym is, but both of them are more cognition tests than capacity tests, because they're asking you things like draw a clock, remember 5 words from when they say them at the beginning, and they have you repeat them at the end, counting back from 107s, um, drawing a house sometimes, um, and some word association stuff. So the reason why that's not really indicative of capacity or the ability to consent to something is because if you didn't make it past grade 5, you wouldn't be able to do a lot of that test because you just didn't learn those skills. If you have English as your second language, you might get some of these things wrong just because you're doing a test not in your mother tongue. So it's not a great capacity test. Sometimes people bring them up in court because, if you show the person got perfect and the next year they got only half right, then we've clearly got a huge reduction in their cognition. And so that might speak to losing capacity. But if it's just one random test and that's it, we don't know because we don't have any other tests to know if that's just your baseline. So that's why I don't love those ones. They can be kind of indicative, but they're not the greatest. Um, Sometimes if they're being done by someone's GP and that GP has known them for a long time, that it might help them in being able to say, look, I think you should have been able to answer these. I want to refer you to a specialist or something like that to get further testing. But capacity tests can also be more informal. So, for example, when someone comes to see me um, and there's a concern about capacity, or they let me know that they've just been diagnosed with early stage dementia or something like that. Sometimes I'll ask for a letter from the GP just to get their opinion on things. But otherwise, I'll just ask the questions to the client here. And if I'm overly concerned that you don't know where you bank, you don't know what the date is, you didn't get here yourself and didn't know you had this appointment, you have no idea what your bills are or what your income is, then I'm going to be more concerned and say I need you to get a capacity assessment for me to be able to draft your wills and powers of attorney. But if you come in and you tell me I bank here, here's my bank statements, my bills, I pay them myself at the bank every month, my income, I have CVP, OAS, I have my pension from my work, I have my savings here, my RSP, my tax-free savings account, then I know you're aware of what you have, and you know what you want to do, you know who you want to inherit, your executors, you understand what a will is and a power of attorney and the difference and all of that. Then I've done more of an informal capacity assessment to make sure that you understand what you're doing. So that's what GPs can do as well. Long-term care homes, they're getting more formalized, but they're not using an actual capacity assessor to do that. They just have their own kind of formula and questions they ask to see if someone's capable of making the decision to go into long-term care or not. So I told you we're getting to this. Are there different kinds of capacity? And yes, there are. The most common, and this is kind of in order of like the highest level of capacity to the lowest. But to make a will, that's the top thing that you would do with a lawyer, that you need to have the most capacity for. You need to understand the most things, and what you're doing. To make a power of attorney for property, so that's financial decisions, that's the next highest. To make your power of attorney for personal care, that's lower than that because your ability to understand personal care decisions is usually lasts longer than your ability for finances. The ability to instruct a lawyer, so you might be able to instruct a lawyer on a litigation file or something like that, but not be capable of making a will, just because there's a different understanding level for those. And then there's making your own financial decisions. So you may lose the capacity to do a power of attorney, but you haven't lost the capacity to still pay your own bills and do your own things because they're a different standard between the two. Same with personal care decisions. You might not be able to make your power of attorney, but you're still able to make your own decisions. Getting married actually requires capacity, but a very, very low bar. And same with your decision to go into long-term care to be able to understand if you need to be there, if you're okay going to be at home. And so all of, I would say, except for the bottom two, all of the rest, a capacity assessor has different questions they ask, different notes they take, and a different way they deal with it depending on which one you're asking them to assess for. So the other interesting thing about a capacity assessor is you can hire them just to do one of those things, or you can hire them to do all of those things. It's part of when you talk to them and they talk to the families to make sure they know what capacity they're assessing. And when they do that as well, if they're assessing whether you're capable of making your own financial decisions or healthcare decisions, that's a very specific test under a statute, and they're required to give to the person who was assessed and give to the public guardian and trustee if they find that they're not capable, so that the person knows and the public guardian and trustee knows. Because if there's no power of attorney, the public guardian and trustee takes over to make the decisions, or at minimum, the financial decisions. So what happens if you're found not to be capable? If you get one of those statements from an assessor or from a doctor at a hospital. So the substitute decision maker steps in. And substitute decision maker, or SDM, that's created in the Healthcare Consent Act and the Substitute Decisions Act. So if you're ever dealing with a hospital or healthcare providers, they might say SDM to you, and that's what they're talking about. Who gets to make decisions for you if you're not capable of making them yourself? So when that decision's made and you're found not to be capable, you have a right to appeal that decision to the Consent and Capacity Board. So in Ontario, we have our courts, and then we also have a board system. The most common one that people know about is the Landlord-Tenant Board. So this is the same idea. The Consent and Capacity Board has some lawyers and doctors on it. It usually sits in a panel. And remember my example with the person who's getting formed because they're having a manic episode? On that form they're given, it actually says on there, you have the right to appeal this Consent and Capacity Board, and you just have to either check the box or tell the doctor that you want to do that, and they'll arrange it. The Consent and Capacity Board does do urgent hearings because most of the time you're detaining someone, and so they don't want someone to be waiting weeks to get in front of the board to make a decision if they have to be there or not. So it is relatively quick to go through that process. The Consent Capacity Board is actually also the place you go to if, say, he's named more than one person as your power of attorney for healthcare, and they can't agree on what to do, then you can actually take that to the Consent Capacity Board and have them decide, which is much faster than going through the court system. And it's also where you go if you disagree with what the doctor's going to do. You can go there and they can make a ruling on it. So you can pause whatever the doctor's doing and have that reviewed. So let's talk about who can be your substitute decision maker. So it's the person you've named in your power of attorney for property or personal care. If you don't have that, then for healthcare decisions, the statute, the Healthcare Consent Act, it says who that is, and it basically follows your family tree. So it's spouse, kids, parents, siblings, and then it goes out farther from there. Public guardian and trustee is the next one over. So they step in if we don't have anyone in the first two. They're a government body, they're government employees. They have their main offices in Toronto, but they do have some offices in London and I believe still in Hamilton. But there's always delay when they step in, and you've obviously got someone who's not familiar with you making decisions for you because they're just, I guess, assigned to whoever in the office. And then there's court appointing guardians. So if somebody we don't have any of the others, and your family wants to step in, they can apply to the court to be appointed your guardian, and then the public guardian and trustee stops. There's two processes with that. One, if the public guardian and trustee is already in place and you're a family member, you can apply to the public guardian and trustee and they will go through their process to be in front of a judge to get you appointed if you meet certain requirements. If you don't meet those requirements, then we've got to go to regular court, and we have to get a judge to make that decision, or if people are fighting about it. So if we've got siblings against siblings and they say, I want to do it, and the other side wants to do it too, then we've got to go get a court and get a court order for who it'll be. So obviously the cheapest method is making sure you have your power of attorney done. Which leads right into the next one. So planning ahead. Power attorney for personal care, that's your healthcare decisions. You can also put in there if you have any specific wishes about end of life or treatment decisions. Your power of attorney for property, which covers your finances. And then when you're doing those, choose someone who knows your values, who knows what you would want, who manages things as you do. If you have like 5 kids to choose from, and the 3 of them are horrible with money, and one of them's great and is a financial planner, that might be the one to choose because it's in their skill set, right? And you've got another kid who's a nurse, again, in that person's skill set. But if you say, for example, you want to, you'd want to use MAID or you would want to be unplugged, and the person you want to name is highly religious and disagrees with that and would be unlikely to respect that wish, then you've got to think about who you're naming and what's more important to you. So what can you do now? You can create or review your powers of attorney, make sure they reflect what you want to do or get them done so they reflect what you want. Talk to your family and advisors. Make sure they know what you would want, which really helps with arguments later if you've got a lot of people in your life that are going to be making those decisions with you. It's a good idea as you get older to, if your GP wants a copy, to give them a copy of your power of attorney, or at least let them know who your power of attorney is. So that if something were to happen and no one knows, it's an extra person who's got that answer. But also your financial advisors. So if you've got your money invested with someone, you should be probably at least talking to them once a year and reviewing your stuff. You can always make sure that they've got on file of who your power of attorney for finances or for property is, so that if they're concerned about something, then they know who it is and who they could potentially call to see what's going on. And the other last thing is know your rights and ask questions. Because remember, that first part of consent is that it's informed. So before you get pushed into making a decision about something, make sure you understand everything about that decision and how it affects you. And take the time that you need to take to be able to make the decision. And ask as many questions as you want, speak to as many people as you need to. But take your time with it so that you make sure that you're doing what's right for you. All right, we got to the questions part.